Hello, my name is Pat Liu, and I'm a senior at the Bronx High School of Science. I'm part of Legal Outreach, a four-year college-bound program in which we debate constitutional law issues. The issues being examined in the case Turner v. Ryan are seizure by deadly force under the Fourth Amendment and qualified immunity under the United States Constitution, Section 1983. I represent the respondent Dwight Lucius Ryan, and I claim that Officer Turner unreasonably used deadly force to seize him and is not eligible for qualified immunity.
Same thing, I'll start timing as soon as you start speaking. Judges ready?
May it please the court, my name is Pat Liu, and I represent the respondent, Dwight Lucius Ryan. The issues we have today are whether Lucius's Fourth Amendment rights were violated when Officer Turner used deadly force to seize him, and whether Officer Turner is eligible for qualified immunity under USC Section 1983. We request the court find that Officer Turner unreasonably used deadly force to seize Lucius and is ineligible for qualified immunity. While Lucius was attending a launch party for his son, he broke up an altercation between his ex-wife and his current wife. In doing so, he violated Ms. Calhoun's restraining order against him. Afraid he'd be arrested for such a minuscule violation, Lucius got in his car and drove away. Officer Sanchez and Officer Ryan engaged in a car chase after Lucius. Officer Ryan, who was Lucius's son, set up road spikes several miles ahead of Lucius. That was when Officer Turner joined the chase from 15 miles away. Despite his captain's express orders to stand down, Officer Turner continues to fire 8 rounds at Lucius's car and kills him. Under the Fourth Amendment, a person has the right to be secure from unreasonable searches and seizures. According to Garner, and later expanded upon by Bond, a police officer is justified in using deadly force if the totality of the circumstances allows for it. These circumstances include whether the suspect poses an immediate threat to others, whether it is necessary to prevent escape, and whether a warning was solicited beforehand. In Scott and Plumall, the court focused on the driver's behavior that may pose an immediate threat to others, and the preventative measures taken before using deadly force. When Lucius was approaching the overpass, he was doing 60 miles per hour compared to the 100 miles per hour when the chase started, suggesting that he was slowing down. The petitioner may argue that he intended to harm Officer Ryan, who was underneath the overpass, but that belief was based on personal vendetta and not on objective reasoning under the totality of the circumstances. Moreover, the petitioner's negligent action itself could have harmed Officer Ryan. Although his alleged intention was to hit the car engine, he had no prior experience in disabling a car engine with a firearm and ended up shooting multiple shots from a long distance. Under the totality of the circumstances, Officer Turner unreasonably used deadly force to seize Lucius and is therefore violated his Fourth Amendment rights. When a state actor has been accused of violating or depriving a person of their rights under the color of the law, the petitioner can file a claim of qualified immunity under USC Section 1983. According to Harlow and Presley, qualified immunity allows officials to make reasonable but mistaken judgments, except for those who are plainly incompetent or those who had fair notice before violating the law. The petitioner had fair notice that he was violating the law because he deliberately chose to disobey his captain's orders, which are usually representative of upholding the laws. Brousseau tells us to look at previous cases relevant to our situation. Looking at Bond, for example, it also had a police officer who tried to disable a car engine but ends up shooting the suspect by accident. However, the police officer in Bond tried alternate measures before resorting to deadly force, whereas Officer Turner didn't give the road spikes a chance before pulling the trigger. Even if the petitioner did not have actual knowledge that he was violating the law, he was nevertheless plainly incompetent. Not only did he have no experience of disabling an engine with a firearm, he fell asleep during police training sessions. Therefore, even if the court finds that the petitioner's action was reasonable but mistaken, he was clearly incompetent in his job duties and is ineligible for qualified immunity. If the court rules in favor of the petitioner, it will have long-term detrimental effects. It would encourage police officers to use deadly force irresponsibly, which would result in more unwarranted harm to the public. In summary, we request the court to uphold the lower court's decision and find that Officer Turner unreasonably used deadly force to seize Lucius and is ineligible for qualified immunity as stated. Thank you.
Thank you.
So the petitioner is trying to paint a picture of Lucius being a dangerous man, one who's going extremely fast on this highway, and or a situation where Officer Turner has to make a split-second decision. But is that really the case? He has time to set up his rifle on the overpass. He has time to absorb everything that's going around. He knows that tires are set up behind him, and he understands that this captain told him to stand down, as well as his other fellow officers. It's not a split-second decision what we have here. Officer Turner fired because of his personal vendetta, and in addition, Lucius was slowing down. He was doing 60 miles per hour, not 100 miles per hour when the chase began, suggesting that he was conceding to the police officers. And deadly force is only justified if it's necessary to prevent him from escaping. But we don't really know, or a reasonable officer wouldn't think that deadly force is necessary because road spikes were set up and Turner didn't give him a chance before using deadly force. Thank you.
Thank you.